Before we begin, please remember that this presentation is for informational and educational purposes only. I am not an attorney, and the information provided in this video does not, and is not intended to, constitute legal advice. Every situation is unique, and the laws vary by state and school district. You should consult with a qualified professional for advice regarding your individual situation. A mother I know, let's call her Sarah, was at her breaking point. Her 8-year-old son Liam was a whirlwind of energy and bright ideas at home. But at school, he was failing. Not just struggling, but actively failing. His report cards were a sea of red ink. His teacher said he was disruptive, inattentive, and unmotivated. Every afternoon, Sarah would brace herself for the phone call from the principal's office or the frustrated note tucked into Liam's backpack. She went to meeting after meeting. She sat in those tiny chairs in the guidance counselor's office, trying to explain that the boy they were describing wasn't the son she knew. They nodded sympathetically. They suggested sticker charts. They recommended he get more sleep. One administrator even told her with a shrug, "Some kids just don't like school." Sarah felt like she was screaming into a void. Her smart, creative son was being labeled a problem, and the system designed to educate him was instead crushing his spirit. She felt powerless watching her son's light dim day by day, and she had no idea what to do next. This feeling of helplessness is a nightmare shared by millions of parents across the United States. You know your child better than anyone. You see their potential, their struggles, their unique way of seeing the world. But when you're up against a school district, an institution with its own rules, its own language, and its own team of administrators, it can feel like an impossible fight. But what if I told you there's a resource, a professional advocate, whose entire job is to level that playing field? Someone who speaks the school's language, understands the labyrinth of laws protecting your child, and can turn those frustrating meetings into productive, game-changing sessions. That advocate is an education lawyer. And over the course of this presentation, I'm going to pull back the curtain on one of the most misunderstood and underutilized resources available to parents. You are going to learn exactly what an education lawyer does, the critical signs that indicate you might need one, and how they can become the most powerful ally you have in securing the education your child not only needs, but is legally entitled to. We're going to transform that feeling of powerlessness into a feeling of empowerment, armed with knowledge and a clear strategy. So why is this even necessary? Why does a parent need a legal expert to navigate a public school? The truth is, the American education system is incredibly complex, far more than most people realize. It's not just about teachers and textbooks. It's a massive bureaucracy governed by a dense web of federal, state, and local laws. Think about the Individuals with Disabilities Education Act, or IDEA, or Section 504 of the Rehabilitation Act. These are powerful federal laws that grant specific, enforceable rights to students. But they are written in dense legalese, filled with acronyms and procedural requirements that can make your head spin. IEPs, LREs, FBAs, BIPs. It's an alphabet soup designed by and for the system, not for the average parent. The school administrators you meet with, they live and breathe this stuff. It's their full-time job. They've been through hundreds of these meetings. They know the procedures, the timelines, and the exact language to use. When you, as a parent, walk into that room, you are fundamentally at a disadvantage. You are driven by love and concern for your child, but you are an amateur in a professional's arena. The school district has a team. They have policy experts, specialists, and when things get serious, they have their own lawyers on retainer. Who's on your team? For most parents, the answer is nobody. You're on your own. This power imbalance is the root of so much frustration. It's why valid concerns get dismissed. It's why children with learning disabilities like dyslexia or ADHD get labeled as lazy or disruptive. It's why bullying goes unaddressed, or why unfair disciplinary actions stick. The system is designed to be efficient for the masses, and a child who doesn't fit neatly into the pre-made boxes can often be seen as a problem to be managed rather than a student to be understood. This is where the entire dynamic shifts. An education lawyer isn't just someone you hire to sue the school. That's a massive misconception, and frankly, it's usually the last resort. Think of an education lawyer as a translator, a strategist, and a negotiator all rolled into one. First, they are a translator. They take the school's jargon-filled reports and legalistic notices and explain them to you in plain English. More importantly, they take your parental concerns, your deep knowledge of your child, and translate them into the formal language that the school district is legally required to act on. A phrase like, "I'm worried Liam is zoning out in class," becomes a formal request for an evaluation to assess for an attention-based disability, citing specific legal obligations the school must follow. Suddenly, you're not just a worried parent. You're a stakeholder asserting your child's legal rights. Second, they are a strategist. A good education lawyer looks at the big picture. They're not just thinking about the next report card. They're thinking about your child's entire educational career. They'll review years of school records, teacher notes, and evaluations to identify patterns the school may have missed. They'll help you understand the difference between an IEP and a 504 plan and strategize which one is the right tool for your child. They chart a course, helping you anticipate the school's next move and preparing you for every possible outcome. Finally, and most critically, they are a negotiator. Imagine walking back into that conference room, but this time you're not alone. Sitting next to you is a professional who knows the law cold. The entire tone of the meeting changes. The subtle dismissals and vague promises stop. The conversation shifts from what the school feels is appropriate to what the law requires. Your lawyer ensures that procedures are followed, that your voice is heard and respected, and that the services put in place are not just what's easiest for the school, but what is necessary for your child to receive a free, appropriate public education. They level the playing field instantly. Let's go back to Sarah and Liam. After another disastrous parent-teacher conference, a friend mentioned education law. Sarah was hesitant. It sounded extreme, expensive, and confrontational. But drowning in desperation, she made the call. It was the single most important decision she ever made for her son. The lawyer listened to her story for over an hour. Then she requested Liam's entire school file. Within a week, she called Sarah back. The lawyer had found a dozen red flags: inconsistent teacher reports, a failure to implement suggested interventions, and a complete lack of formal testing despite years of documented concerns. The lawyer's first move wasn't a lawsuit. It was a letter. A calm, professional, but legally powerful letter requesting a comprehensive, independent educational evaluation at the district's expense. A right parents often don't even know they have. The district, recognizing they were now dealing with someone who knew the law, immediately agreed. The evaluation was a revelation. It discovered that Liam had a significant processing disorder and dysgraphia, a learning disability that affects writing. He wasn't being disruptive for fun. He was profoundly frustrated because he couldn't process information at the same speed as his peers and couldn't get his thoughts down on paper. His acting out was a desperate cry for help. Armed with this expert report, Sarah and her lawyer went to the next school meeting. It was like night and day. There were no more excuses, no more sticker charts. The conversation was now about solutions. Liam was immediately approved for an Individualized Education Program, or IEP. He received specialized instruction from a learning specialist, was given access to assistive technology like a laptop for writing, and was granted extra time on all of his tests. The transformation was staggering. Within 6 months, Liam wasn't just passing. He was excelling. The problem child disappeared, and in his place was a confident, happy kid who finally had the tools he needed to succeed. The phone calls from the principal stopped. The anxious nights for Sarah ended. The lawyer didn't just win a case. She gave Liam back his future. Now Liam's story is dramatic, but the core of it is something thousands of parents face every single day. It's the feeling of being completely outmatched. You're sitting in a small windowless room across a table from a team of people: the principal, a school psychologist, a special education coordinator, multiple teachers. They all have advanced degrees, years of experience, and they're all using acronyms you've never heard before. FAP, LRE, BIP, IEP. It feels less like a collaborative meeting and more like an interrogation you didn't prepare for. They hold all the cards. They have the budget, the staff, the institutional knowledge, and, most importantly, they have their own lawyers on retainer. You, the parent, have a binder full of notes, a pounding heart, and the sinking feeling that you're the only person in that room whose sole job is to advocate for your child. This is the chasm that an education lawyer is built to cross. So what exactly is an education lawyer? They aren't the corporate lawyers you see in skyscrapers, or the personal injury lawyers you see on billboards. They are specialists, a niche breed of attorney who lives and breathes the complex web of federal and state laws that govern our public school system. Their entire world revolves around ensuring that every child receives the education they are legally entitled to. They are translators, turning that confusing alphabet soup of acronyms into a clear plan of action. They are strategists, understanding the pressure points of a school district. And most importantly, they are equalizers. When an education lawyer walks into that room with you, the power dynamic at that table instantly shifts. You are no longer just a worried parent. You are a parent with a legal expert who knows the rulebook better than the people who are supposed to be following it. To understand their power, you have to understand the two bedrock laws they operate under. Think of these as the Constitution for students with disabilities in America. The first, and the big one, is the Individuals with Disabilities Education Act, or IDEA. This is the law that gave Liam his one-on-one aid and his specialized reading program. IDEA guarantees every eligible child with a disability a free appropriate public education, a term you'll hear a lot, so let's just call it FAPE. Now the word appropriate is where all the battles are fought. Appropriate doesn't mean the best possible education money can buy. It doesn't mean a private school with a pony for every student. It means an education that is specifically designed to meet your child's unique needs, in a way that allows them to make meaningful progress. If your child isn't making progress, if they're falling further and further behind year after year, then their education is likely not appropriate, and the school is failing to meet its legal obligation under federal law. IDEA is what mandates the creation of the Individualized Education Program, the IEP, which is the legally binding contract between you and the school district that outlines every single service, support, and goal for your child. The second major law is Section 504 of the Rehabilitation Act of 1973. This is a civil rights law. If IDEA is about providing specialized instruction, Section 504 is about providing access. It prevents discrimination against people with disabilities. In a school setting, this often takes the form of a 504 plan. This is for students who may not need the intensive special education services of an IEP, but who still need accommodations to level the playing field. Think of a student with severe ADHD who doesn't need a special class but needs extra time on tests to demonstrate their knowledge. Or a student with diabetes who needs a plan in place to monitor their blood sugar. Or a student with anxiety who needs the ability to take a short break in a quiet room during a panic attack. Section 504 ensures that a child's medical or mental health condition doesn't prevent them from accessing the same education as their peers. An education lawyer knows the nuances between these two laws. They know when a child's needs fall under the umbrella of an IEP versus a 504 plan, and they know how to argue for the right one with the right supports. So, knowing this, when is the moment you should actually pick up the phone and call one? It's not necessarily the first time you have a disagreement, but there are very clear red flags, moments where the system is signaling that it's not going to work with you easily. The first red flag: the school is denying your request for an evaluation. You see your child struggling. You've read the books, you've talked to their doctor, and you believe they may have a learning disability like dyslexia or dyscalculia. You put your request for an evaluation in writing, as you should. And the school comes back and says, "No, we don't think it's necessary. Let's just wait and see." This wait-and-see approach, also known as watch them fail, is a huge red flag. Your right to request an evaluation is protected by law. A school's refusal is often the first sign that you're in for a fight, and it's a good time to get legal advice. The second red flag: the school conducts an evaluation, but tells you your child doesn't qualify for services, even though you have a report from a private psychologist or doctor that says they do. The school's evaluation might be incomplete, or they might be interpreting the results in a way that serves their budget, not your child. An education lawyer can hire their own independent experts to scrutinize the school's testing, find the flaws, and present a case that is impossible to ignore. A third and very common red flag: your child has an IEP, but it's not being followed. The IEP is a legal contract. It's not a list of suggestions. If it says your child is supposed to get 30 minutes of speech therapy twice a week, and the therapist is consistently canceling, that's a breach of contract. If it says your child gets to use a keyboard for all written assignments, and a specific teacher refuses to allow it, that's a violation of federal law. A lawyer can force the school into compliance, and in some cases, get you compensatory services to make up for the support your child lost. And here's a critical one: your child is facing serious disciplinary action, like suspension or expulsion. This is especially crucial if the behavior is linked to their disability. Think of a child with autism who has a meltdown due to sensory overload and is suspended for being disruptive, or a child with ADHD who is suspended for impulsivity. This is called a manifestation. Federal law provides specific protections for students with disabilities to ensure they are not being punished for their disability. An education lawyer is absolutely essential in these situations, which are called manifestation determination reviews. to protect your child from being pushed out of school. Let me tell you about Maria and her son David. David was a bright, funny 7th grader with severe dyslexia and ADHD. His IEP was solid on paper, but middle school was a different beast. He had 6 different teachers and the communication broke down. His accommodation to have test questions read aloud was rarely happening. He was supposed to get notes provided for him, but he was too embarrassed to ask. His grades plummeted. He started acting out in class, becoming the class clown to hide the fact that he couldn't keep up. The school's response? They started suspending him. 1 day for talking back, 3 days for disrupting class. Maria was at her wits' end. At a meeting, the school suggested moving David to an alternative school for students with behavioral problems. They framed it as a fresh start. Maria felt cornered. This wasn't a behavior school her son needed. He needed a school that would follow his IEP. She called a lawyer. The lawyer immediately sent a letter to the district, putting a stop to the transfer. He requested an emergency IEP meeting and laid out, teacher by teacher, class by class, every single instance where the IEP was violated. He showed how David's behavior problems directly correlated with the school's failure to provide his academic supports. The district's tone changed instantly. The threat of moving David disappeared. Instead, they implemented a system to ensure every teacher was following the IEP and provided David with a tutor to catch up on what he'd missed. They didn't just save him from being sent to the wrong school. They saved his academic career. The final red flag is simpler. It's when you just feel it in your gut. When you leave every meeting feeling defeated, unheard, and overwhelmed. When you feel like the school is more interested in saving money than in helping your child. That feeling is your intuition telling you that the power is imbalanced. That's the signal that you need someone in your corner. Because navigating this system alone is a monumental task. But what exactly happens in those dreaded IEP meetings? And how does a lawyer transform a conversation you're losing into a negotiation you can win? The answer involves a specific set of strategies that schools hope you'll never learn. Let's start with the most common misconception about an IEP meeting. That it's a collaborative, friendly chat about your child. In a perfect world, it would be. But in reality, for many parents, it's an ambush. You walk into a conference room, and on one side of the table, it's you. Maybe your spouse. On the other side, a principal, a special education director, a school psychologist, a general education teacher, a speech therapist, and maybe even a district representative. 7 people, all employed by the school, all familiar with the process, all speaking a language you don't fully understand. The power dynamic is set before anyone even says hello. It's designed, consciously or not, to be intimidating. It's designed to make you feel outnumbered and grateful for whatever they offer. This is where the game changes with a lawyer. The first, most critical strategy happens before you ever set foot in that room. It's about seizing control of the narrative. Your lawyer will make a formal, written request for a copy of the school's proposed draft IEP and all evaluation reports they plan to discuss, at least 5 days before the meeting. This is your right under federal law. But it's amazing how often schools forget to do this. They prefer to present it to you for the first time in the meeting itself, when you're under pressure, flustered, and have no time to process a 20-page legal document. Getting that draft in advance is like being handed the other team's playbook before the Super Bowl. Suddenly, you're not reacting in the moment. You and your lawyer can sit down, go through it line by line in the calm of your own home. You can see their opening offer. You can identify the weaknesses. You can see what they left out. Is the description of your child's struggles accurate? Or is it sugar-coated? Are the goals they set ambitious? Or are they laughably low, designed to be easily met so the school can pat itself on the back? Are they offering 30 minutes of speech therapy when your independent evaluator recommended 3 hours? This advance copy turns you from a passive recipient into an active negotiator. The next pre-meeting strategy is setting the agenda. Most parents just show up. A lawyer will submit a parent agenda ahead of time. This is a formal list of your concerns and the specific topics you want to cover. This simple document fundamentally alters the meeting's structure. It's no longer just the school's show. You've now formally stated that you will be discussing the need for a one-on-one aid, the lack of progress in reading, and the bullying incidents on the playground. They can't ignore it. They can't say they ran out of time. It's on the record. This leads to the third, and perhaps most powerful pre-game move: creating a paper trail. From the moment a lawyer is involved, every communication is documented. Every phone call is followed up with an email summarizing the conversation. Dear Principal, thank you for taking the time to speak with me today. As we discussed, you agreed to provide the last 3 years of testing data for my client. Suddenly, those vague verbal promises that so often disappear into thin air become concrete, time-stamped evidence. This isn't about being adversarial. It's about being professional. It forces the school to operate with a level of accountability they simply may not be used to when dealing with parents alone. Now let's go inside the meeting room. With a lawyer by your side, the entire dynamic shifts. They are not just a warm body. They are a translator, a shield, and a strategist. First, the translator. The school staff will start throwing around acronyms like a foreign language. FAPLRE BIP RTI PLP. It's designed to confuse you and establish their expertise over yours. Your lawyer will politely stop them. Excuse me, can you please explain for the record what you mean by LRE in the context of this child's specific needs? And can you show us in the data where it supports this as the least restrictive environment for him to make meaningful progress? They cut through the jargon and force the conversation into plain English, leveling the playing field. They ask the questions you might be too intimidated to ask. Second, the shield. Schools have a playbook of tactics to pressure parents into agreeing with them. One of the most common is the "we're a team" tactic. They'll say, "Now we're all on the same team here, we all want what's best for Johnny." It sounds wonderful, but it's often used to shut down disagreement. When you push back, you're suddenly not a team player. A lawyer can neutralize this instantly. We absolutely agree. And because we are a team that wants what's best for Johnny, let's focus on the objective data in this third-party evaluation, which clearly shows that the district's current approach is not working and a more intensive intervention is required by law. They affirm the team concept but pivot it back to the facts and the school's legal obligations. Another favorite is the limited resources excuse. A full-time aide for your daughter? We'd love to, but the budget just isn't there. This is where a lawyer is invaluable. They will calmly, professionally remind the entire team that a free appropriate public education, or FAPE, is a federal mandate. The school's budget problems are not a legally permissible reason to deny your child the services she needs to make progress. It's like a restaurant saying they can't afford to cook your food safely. It's not an excuse, it's their fundamental obligation. Then there's the wait-and-see approach. The school proposes a week plan and says, "Let's just try this for a few months and see how he does." For a child who is drowning academically or emotionally, a few months is a lifetime. It's educational malpractice. Your lawyer will reframe the conversation. "My client's child has already been waiting and seeing for 2 years, and the data shows he has fallen further behind his peers. The law requires a plan that is reasonably calculated to confer meaningful educational benefit now, based on his present needs, not a plan to see if he fails a little less slowly." Let me tell you about a boy we'll call Liam. Liam was a brilliant, funny second grader who couldn't read. For 2 years, his parents were told he was just a boy being a boy, a late bloomer. Finally, after a long fight, they got an IEP meeting. The school team, all 6 of them, sat across from Liam's parents and presented their plan. 30 minutes of reading help, twice a week with a teacher's aide who had no specialized training. His parents knew in their gut it wasn't enough, but they were overwhelmed. The psychologist assured them this was the standard protocol. The principal smiled and said, "Let's just give this a try." Feeling pressured and defeated, they signed. A year later, Liam was in 3rd grade and functionally illiterate. He was starting to act out in class, calling himself stupid. His parents, desperate, scraped together the money to hire an education lawyer. The first thing the lawyer did was get an independent neuropsychological evaluation. The results were clear. Liam had severe dyslexia and needed intensive, one-on-one instruction using a specific, evidence-based method, for at least 1 hour every day. The lawyer submitted the report to the school and called a new IEP meeting. This time, when the school offered the same 30-minute plan, the lawyer didn't argue. He simply placed the 40-page evaluation on the table. He walked the team through the data, the diagnosis, and the legal definition of an appropriate education. When the special education director started talking about budgets, the lawyer calmly cited the federal law. When the principal said, "This isn't how we usually do things," the lawyer replied, "The law doesn't care about how you usually do things. It cares about what this specific child needs to learn. And the undisputed evidence says he needs this." There was no yelling, no courtroom drama, just a calm, firm presentation of facts and law. The power in the room had completely shifted. 2 weeks later, The school district agreed to pay for Liam to attend a specialized private school for children with dyslexia because they couldn't provide the required services in-house. The lawyer didn't have a magic wand. He simply used the rules of the game, rules the school was counting on Liam's parents not knowing, to force the district to do what the law required all along. This is the power of a lawyer in the room. They changed the math. But what happens when the school, even in the face of overwhelming evidence and a brilliant lawyer, digs in its heels and just says no? What happens when the meeting ends in a stalemate? That's when the fight moves out of the conference room and into a whole new arena. That's when you unleash the legal mechanisms that truly hold a school's feet to the fire. The first legal mechanism is called mediation. Think of it as a formal, structured negotiation with a referee. It's a voluntary process where you, your lawyer, the school district's representatives, and their lawyer all sit down with a neutral third-party mediator. This mediator isn't a judge. They can't force anyone to do anything. Their entire job is to help the two sides find common ground and reach a legally binding agreement. Now you might think, I can negotiate. I don't need a lawyer for that. But this isn't like haggling for a car. The school district comes to mediation with their own legal counsel. They know the law, they know the pressure points, and they know exactly what they can and cannot legally get away with. Without a lawyer, you are walking into a professional legal negotiation completely unarmed. Your education lawyer's role in mediation is multifaceted. First, they prepare you. They help you define your bottom line. What is the absolute minimum your child needs to succeed? What are you willing to compromise on? What are your non-negotiables? Going in with a clear strategy is half the battle. Second, during the mediation, your lawyer does the talking. They articulate your child's needs not just in emotional terms, but in legal terms. They'll say, my client's child, Leo, isn't just struggling with reading. He has a formal diagnosis of severe dyslexia, and under the Individuals with Disabilities Education Act, the district is required to provide a program that is reasonably calculated to confer meaningful educational benefit. The current proposal of 30 minutes a week in a reading group of 5 students does not meet that legal standard, and here are the 3 independent evaluations and 5 peer-reviewed studies that prove it. See the difference? You're no longer just a concerned parent. You are a legal party presenting a case. The lawyer also analyzes any offers the school makes on the spot. The school might offer a small concession like moving Leo to a smaller group. It sounds like a win, but your lawyer knows it's not the intensive one-on-one instruction the experts say he needs. They'll advise you that accepting this offer is a trap. It might quiet the situation for a few months, but it won't solve the underlying problem, and you'll be right back here in a year, with a child who has fallen even further behind. Let's say in Leo's case, mediation fails. The school offers a slightly better program, but it's still not the specific, evidence-based Orton-Gillingham instruction his evaluators demanded. The district's lawyer says, "This is our final offer. Take it or leave it." Your lawyer looks at you, you shake your head, and they turn to the mediator and say, "We're at an impasse. So what now?" This is where we escalate. This is where we move from negotiation to litigation. This is when your lawyer files for a due process hearing. And I need you to understand this. A due process hearing is, for all intents and purposes, a trial. It is the single most powerful tool parents have to enforce their child's rights. And it is absolutely, positively not something you can or should ever attempt to do on your own. This is the Super Bowl for education lawyers. Filing for due process starts with a formal, written document called a due process complaint. This isn't just a letter saying you're unhappy. It is a detailed legal document, drafted by your lawyer, that outlines every single way the school has violated your child's rights under the law. It lists every failed promise, every service denied, every assessment ignored. It has to be surgically precise because any issue you fail to raise in that initial complaint, you may be barred from bringing up later. Once that complaint is filed, a legal clock starts ticking, and a process called discovery begins. This is where your lawyer's power becomes undeniable. During discovery, your lawyer can legally compel the school district to turn over documents they would never, ever show you otherwise. We're talking about internal emails between the special education director and the principal, staffing memos, budgetary documents, your child's entire, unredacted educational file. In Leo's case, let's imagine what his lawyer finds. They find an email chain where the director of special ed writes to the school principal, "The parents are asking for Orton-Gillingham. The private tutor they want costs $10,000 a year. We simply don't have that in the budget." Push back with our standard reading program. And the principal replies, "Got it. Will do." That email is a smoking gun. It is a potential game changer. Why? Because the law is crystal clear. A school district cannot deny a child a free appropriate public education, or FAPE, because of cost. A school's budget is their problem, not your child's. Finding that one email can be the difference between winning and losing the entire case. And you would never have seen it without a lawyer using the legal power of discovery. As the hearing date approaches, your lawyer shifts into trial prep mode. They will spend hours preparing you to testify. They'll go over the questions they'll ask you, and more importantly, they'll prepare you for the questions the school's lawyer will ask you on cross-examination. They will also prepare your expert witnesses, that private psychologist or neuropsychologist who evaluated your child. They ensure their testimony is clear, compelling, and directly linked to the legal standards of the idea. Then comes the hearing itself. It takes place in a formal setting, presided over by an impartial hearing officer, who acts as the judge. There's a court reporter transcribing every word. The school district will be there with their team of administrators and their lawyer. But this time, you're not sitting across a conference table feeling outnumbered. You're sitting next to your own legal counsel, your champion, who is ready to fight. Your lawyer will give an opening statement, laying out the entire case. They will call you to the stand to tell your story. They will call your expert witness to the stand to explain, in excruciating detail, why the school's program is failing your child and what specific program he needs. And then comes the cross-examination. Your lawyer will get to question the school's witnesses. They will get the school psychologist on the stand. They might ask, "Are you familiar with the Orton-Gillingham approach?" The psychologist says yes. "Is it considered the gold standard for treating severe dyslexia like Leo's?" The psychologist has to admit under oath that it is. "And have you or anyone on your staff been trained or certified in this gold standard approach?" The answer is no. So, to be clear, you're aware of the best, most effective method to teach this child, but you haven't provided it, and you aren't even trained in it? The lawyer will then question the special education director. They will present that email as evidence. "Can you please read this email you sent on October 15th aloud for the record?" The director is forced to read their own words, admitting they denied a service based on cost. The case is building brick by painful, undeniable brick. After all the evidence is presented, both lawyers give a closing argument, summarizing everything for the hearing officer. Your lawyer will tie it all together. The law, the expert testimony, the school's own failures, and that damning email. They will paint a clear picture of a district that has systematically failed to provide your child with the education he is legally entitled to. A few weeks or months later, you receive the decision. It's a lengthy written order from the hearing officer. In Leo's case, the officer finds that the school district denied him a free appropriate public education. The decision is legally binding. It's not a suggestion. It is an order. The hearing officer orders the district to fund, in full, the private, one-on-one Orton-Gillingham tutoring that the experts recommended from the very beginning. This is the power of due process. It takes the decision out of the hands of the very people who were denying your child services and places it in the hands of a neutral legal authority, whose only job is to interpret and apply the law. It is the ultimate check and balance on the power of a school district. It is how you turn a stalemate into a victory. It's how you get your child what they not only need, but what they have a fundamental, federally protected right to receive. The fight might be long and difficult, but with the right legal expert in your corner, it is a fight you can win. Now let's pivot from the world of IEPs and special education to another area where the stakes are just as high, if not higher: school discipline. Because what happens when the system designed to educate your child becomes the system trying to expel them? What happens when one bad day, one mistake threatens to derail their entire future? This isn't a hypothetical. This happens every single day in schools across America. And it's in these moments of crisis that an education lawyer becomes not just helpful, but absolutely essential. Imagine this scenario. Let's call our student Michael. He's 15, a decent student, never been in any serious trouble. One afternoon, you get the call that every parent dreads. The principal's voice is grim. There was an incident, a fight. Michael was involved. He's been suspended for 10 days, and the school is recommending him for expulsion. Expulsion. The word hits you like a physical blow. It's a scarlet letter in the world of education. It can prevent a child from getting into another public school, harm college prospects, and follow them for years. Your mind is racing. You try to ask questions, but the answers are vague, bureaucratic. You're told there will be a hearing. You'll have a chance to tell your side of the story. You hang up the phone, your heart pounding with a mixture of fear, anger, and utter helplessness. This feeling of helplessness is by design. The school disciplinary process is an administrative labyrinth, deliberately intimidating for those who don't know how to navigate it. The school holds all the cards. They have the incident reports, the witness statements from staff, and the full weight of the district's authority. They present you with a packet of papers filled with codes and statutes, and they give you a date for a hearing where your child's fate will be decided by a panel of administrators who, more often than not, have already made up their minds. To them, your child is often just a liability, a problem to be removed from the equation to maintain order. Your son Michael, the kid you taught to ride a bike, the kid who still leaves his socks all over the house, is reduced to a case number. This is the exact moment an education lawyer changes the entire game. Michael's parents, terrified and overwhelmed, make the call. And the first thing the lawyer does is hit the brakes. They provide immediate, critical advice. Do not talk to the school anymore. Do not agree to anything. Do not sign anything. This simple act creates a firewall. The school can no longer directly pressure the family. All communication must now go through the lawyer. Power has already begun to shift. Next, the lawyer goes on the offensive, but not in a loud, aggressive way. They do it with paper. They immediately file a formal request, under state public records laws and the Family Educational Rights and Privacy Act, or FERPA, for Michael's entire cumulative file. This includes his grades, attendance records, past disciplinary actions or lack thereof, and any special education records. They also demand every single piece of evidence related to the incident. The full, unredacted incident report, all written witness statements from students and staff, and any and all video footage that may exist from security cameras. The school might drag its feet, but they have to comply. And when that file lands on the lawyer's desk, the real work begins. This is where their expertise becomes invaluable. A parent might see a simple report about a fight. A lawyer sees a tapestry of legal issues. They're not just reading the story the school wants to tell. They are deconstructing it, looking for inconsistencies, procedural errors, and violations of your child's rights. In Michael's case, the lawyer sits down with him, and for the first time, Michael feels safe enough to tell the whole story. The fight wasn't random. He had been the target of relentless bullying for months by the other student involved. He had reported it twice to a teacher, but nothing was ever done. The day of the fight, the other student cornered him, threatened him, and shoved him first. Michael, feeling trapped and scared, shoved back. That's when a teacher walked around the corner and saw only Michael's retaliation. Suddenly, the narrative changes. This isn't a story about a problem child. It's a story about a school's failure to address a documented bullying problem, which then created a volatile situation. The lawyer then scrutinizes the school's actions after the incident. They discover the principal questioned Michael, a minor, for 45 minutes without ever attempting to contact his parents, a potential violation of his due process rights. They find that the written witness statements from Michael's friends, which corroborated the bullying story, were conveniently omitted from the official evidence packet sent to the disciplinary hearing panel. Armed with this information, the lawyer prepares for the expulsion hearing. And when the day comes, the atmosphere in the room is completely different than it would have been if Michael's parents had walked in alone. On one side of the table sits the principal, a district administrator, and perhaps the school's own attorney. They're used to being in control. But on the other side sits Michael, his parents, and their lawyer. The lawyer isn't emotional. They are calm, prepared, and professional. They speak the same language as the district's attorney. They understand the rules of evidence. They cannot be intimidated. The principal presents the school's case. Michael was involved in a fight, a violation of the zero-tolerance policy, and the recommended consequence is expulsion. It sounds simple, clean, and final. Then it's the education lawyer's turn. They don't just plead for mercy. They dismantle the school's case piece by piece. They introduce evidence of the prior, ignored reports of bullying, showing the school was negligent in its duty to provide a safe environment. They challenge the incomplete investigation, pointing out the missing witness statements and demanding to know why exculpatory evidence was withheld. They cross-examine the principal, asking pointed questions about why a minor was interrogated without parental contact. They argue that the school's failure to act on the bullying constitutes a violation of Michael's rights, and that the fight was a foreseeable consequence of the school's own inaction. They then pivot to the punishment itself. They argue that a zero-tolerance policy, when applied blindly, is not only unjust but often illegal. They cite state education law and district policy, showing that expulsion is meant for the most severe, ongoing threats to school safety, not for a student with a clean record who was defending himself in a situation the school itself created. They propose an alternative: a shorter suspension, counseling for Michael to deal with the trauma of being bullied, a mediated session with the other student, and a comprehensive, school-wide anti-bullying plan. They reframe the solution from one of punishment to one of restoration and safety for all students. The hearing panel is now in a completely different position. They are no longer just rubber-stamping a principal's decision. They are facing a clear, well-articulated legal argument that points out the school's own failings. They risk a lawsuit if they proceed with the expulsion, a lawsuit they are now much more likely to lose. The power dynamic has been completely inverted. In the end, the expulsion recommendation is dropped. Michael serves a short, in-school suspension, and the school is compelled to implement the safety and counseling plan the lawyer proposed. His record is clean. His future is intact. This is the power of having an expert in your corner. The lawyer didn't just save Michael from expulsion. They held the school system accountable and forced it to address the root cause of the problem. They transformed a moment of crisis into an opportunity for positive change. This is a world away from a parent, alone and overwhelmed, simply begging a panel of administrators not to ruin their child's life. It's the difference between asking for mercy and demanding justice. And this principle of accountability extends far beyond disciplinary hearings. What happens when the school itself is the source of the danger? What happens when your child is the one being systematically targeted, not for a single incident but day after day? We're talking about severe, pervasive bullying and harassment, and it's a parent's worst nightmare. It's the knot in your stomach when you drop them off. It's the pit of dread you feel when the school's number flashes on your phone. Your child, who you sent to school to learn and to be safe, is instead trapped in a daily cycle of fear and humiliation. You've done everything you're supposed to do. You've emailed the teacher. You've met with the principal. You've filled out the incident reports. You've heard the same tired lines over and over. We'll look into it. We've spoken to the other student. Kids can be kids. We're handling it. But nothing changes. In fact, it gets worse. The whispers in the hallway turn into shoves in the locker room. The mean texts escalate to threats. Your once happy child is now withdrawn, anxious, maybe even physically ill at the thought of going to school. Their grades are slipping, their light is dimming, and you feel utterly, completely powerless. This is the point where many parents give up. They feel like they've hit a wall, a bureaucratic fortress designed to protect the institution, not the child. But here's the critical truth that wall doesn't want you to know. The school doesn't just have a moral obligation to stop this. It has a legal one. Under federal and state law, schools have a non-negotiable duty to provide a safe learning environment, free from harassment and discrimination. When bullying is so severe, pervasive, or persistent that it interferes with a student's ability to learn, to feel safe, to even attend school, it creates what the law calls a hostile environment. And allowing a hostile environment to fester is a violation of your child's rights. So what changes when you bring an education lawyer into this nightmare scenario? Everything. The entire dynamic of the conversation shifts almost overnight. Your desperate, emotional pleas, which were so easy for administrators to dismiss or downplay, are replaced by something they cannot ignore: a formal legal demand. Let's talk about one of the most powerful first steps a lawyer will take: sending a demand letter, or a letter of representation. This isn't just another email for the principal to file away. This is a meticulously crafted legal document, sent to the principal, the superintendent, and often the school district's own legal counsel. This letter does several things with brutal efficiency. First, it puts the school on formal legal notice. This means they can no longer claim they didn't know the extent of the problem. Plausible deniability is officially off the table. Second, it lays out the facts, not as a frantic story, but as a chronological, evidence-based narrative of failure. It details every incident of bullying, every date you contacted the school, who you spoke to, and the school's inadequate response each and every time. It creates a paper trail that is damning. Third, and most importantly, it cites the specific state and federal laws the school is violating. It talks about Title IX if the harassment is based on sex. It references Title VI of the Civil Rights Act if it's based on race or national origin. It brings up Section 504 and the ADA if the bullying is targeting your child's disability. Suddenly, this isn't about a playground squabble anymore. It's about federal civil rights law. It's about liability. It's about the risk of a lawsuit that the district and its insurance company desperately wants to avoid. The conversation is immediately elevated from the principal's office to the district's legal department. The people who now have to respond are the ones whose job it is to mitigate legal and financial risk for the district. And a parent with a competent education lawyer represents a massive risk. Let's imagine a student, we'll call him David. David is a quiet kid who loves science. But for months, a group of students has been targeting him. It started with name-calling, then they started knocking his books out of his hands, then they created a fake social media profile to post humiliating things about him. David's parents did everything right. They met with the school counselor, who promised to mediate. It made things worse. They met with the vice principal, who suspended one of the bullies for a single day. The bullying returned with a vengeance the moment he was back. The school's final offer was to move David to a different set of classes, punishing the victim for the actions of his tormentors. That's when David's parents hired a lawyer. The lawyer didn't just send a letter. She immediately filed a formal anti-bullying complaint under the district's own policy, forcing a documented investigation with a strict timeline. She sent a preservation of evidence notice, demanding the school save all video surveillance, all emails between staff about David, and all disciplinary records of the students involved. She advised David's parents on how to document the ongoing harm, getting a note from David's therapist about his anxiety, tracking his declining grades, keeping a log of every single new incident. When the meeting finally happened, it wasn't just David's parents and a vice principal in a small office. It was David's parents, their lawyer, the school principal, the district's director of student services, and the school district's attorney on speakerphone. The power dynamic had completely flipped. The discussion was no longer about whether David was being too sensitive. It was about the specific, actionable steps the district would take to end the hostile environment they had allowed to exist. The outcome? A comprehensive safety plan was put into place. This wasn't a vague promise. It was a written contract. It stipulated that the bullies would have zero contact with David, with immediate and severe consequences for any violation. It required an aide to monitor the hallways during passing periods. It mandated that David would have a designated safe adult he could go to at any time without question. The district also agreed to provide and pay for compensatory tutoring to help David catch up on the schoolwork he missed, and counseling to help him deal with the emotional trauma. The bullies were moved, not David. The problem was addressed at its source. This is what an education lawyer does. They don't just know the law, they know the system. They know the pressure points. They understand that for a school district, the fear of litigation is a far more powerful motivator than the pleas of a parent. And this applies across the board. Is your daughter being sexually harassed and the school is brushing it off as drama? That's a potential Title IX violation. Is your child being targeted with racial slurs and the school says they can't substantiate it despite multiple witnesses? That's a potential Title VI violation. Is your child with autism being relentlessly mimicked and isolated, and the school calls it social awkwardness? That is disability-based harassment, a major violation of Section 504 and the ADA. When the bullying targets a child's protected status, their race, sex, religion, disability, it transforms from a simple discipline issue into a serious civil rights issue. The school's legal exposure increases tenfold. An education lawyer recognizes this immediately and uses it to force the school to take its legal obligations seriously. The goal isn't always to file a lawsuit. In fact, most of the time that's the last resort. The primary goal is to use the threat of legal action to compel the school to do what it should have been doing all along: protect your child. It's about getting real, enforceable solutions that make schools safe again. It's about securing services to remedy the academic and emotional damage that's been done. It's about turning your powerlessness into power. But what happens when the school isn't just failing to protect your child, but is actively trying to get rid of them? When the phone calls home aren't about bullying, but about your child's own behavior, leading to suspension after suspension. That's the world of school discipline, and it's a minefield where the school holds all the power, or so they think. Let's talk about that phone call, the one that makes your stomach drop. It's the school principal. There's been an incident. Your son, your daughter is being suspended. Immediately, your mind races. What did they do? Are they okay? But then a second wave of feelings hits you. Confusion, frustration, and a sense of complete and utter powerlessness. The school has already made its decision. They've investigated, they've judged, and they've sentenced. Your child is guilty. Case closed. You're just being notified of the punishment. You go to the meeting. You sit in a small office, across the desk from an administrator who has a thick folder with your child's name on it. They use words like insubordination, code of conduct violation, zero tolerance. Feels less like a conversation and more like a verdict being read. They slide a paper across the desk for you to sign, acknowledging the 3-day, 5-day, maybe even a 10-day suspension. And what do most of us do? We sign it. We feel ashamed, maybe angry at our child, but we feel defeated by the system. We take our kid home and hope this whole thing just blows over. This feeling of helplessness is by design. The school discipline process is an intimidating bureaucratic maze. The school holds the cards. They conducted the interviews. They wrote the reports. They interpret their own rules. They are the investigator, the prosecutor, and the judge all rolled into one. And for decades, this has been supercharged by the rise of so-called zero-tolerance policies. These policies were born in the 80s and 90s with a seemingly noble goal: keep schools safe. The idea was simple. For certain offenses, weapons, drugs, violence, the punishment would be swift, automatic, and severe. No exceptions. No excuses. Zero tolerance. Sounds good on a poster. But in reality, it created a system that often values punishment over understanding and compliance over context. It's how a 6-year-old gets suspended for pointing a finger like a gun during a game of cops and robbers. It's how a high school honors student gets expelled for having a bottle of Advil in her backpack because it's a violation of the drug policy. It's a system that can mistake a child's mistake for a criminal act. And here's the critical piece of information they don't put in the student handbook. Your child does not lose their constitutional rights when they walk through the schoolhouse gates. The United States Constitution guarantees something called due process. It's a fundamental principle of American law that says the government, and yes, a public school is a government entity, cannot deprive you of life, liberty, or property without following fair procedures. And a public education is considered a type of property right. A suspension or expulsion is the school taking that right away, even temporarily. So what does due process actually mean for you and your child in a discipline meeting? Means you have rights. Real enforceable rights. First, you have the right to proper notice. This isn't just a phone call saying, "Come pick up your kid." It means you have the right to a written explanation of the specific charges against your child and a summary of the evidence they have. Not vague accusations, but specifics. What rule was broken? Who are the witnesses? What do the reports say? Second, you have the right to a hearing, an opportunity to tell your side of the story. For short-term suspensions, this might be an informal meeting with the principal. But for long-term suspensions or expulsions, we're talking about a formal hearing, often in front of a neutral hearing officer or the school board. This is not a meeting where they just tell you their decision. This is a hearing where you get to present your case. And this is the most important part. At that hearing, you have the right to present evidence. You can bring in emails, text messages, photos, anything that supports your child's side of the story. You have the right to bring your own witnesses, maybe other students who saw what happened, or a family friend who can speak to your child's character. And crucially, you have the right to question the school's witnesses. The administrator can't just say, "Well, another student said your son started the fight." Due process means you have the right to know who that student is and to question their version of events. Now, imagine walking into that hearing armed with this knowledge. The entire dynamic shifts. You are no longer a passive recipient of a verdict. You are an active participant in a legal process. But let's be honest, for most parents this is terrifying. Going up against a school district, questioning a principal, cross-examining witnesses, feels impossible. And that is precisely where an education lawyer becomes your single greatest asset. When a lawyer walks into that room with you, the playing field isn't just leveled. The entire game changes. The school administration knows they can't just railroad you anymore. They know the lawyer understands the specific state laws and district policies even better than they do. They know every procedural shortcut they try to take will be called out. The lawyer transforms the meeting from an exercise of authority into an examination of facts. The lawyer's first job is to become an investigator. They don't just accept the school's folder of so-called evidence. They demand to see everything in it. Every witness statement, every security camera recording, every teacher's note. And often they find things the school conveniently overlooked. Think about a classic he said, she said fight in the hallway. The school talks to one teacher and the other kid, who both point the finger at your child. They suspend your child. End of story. But your lawyer starts asking questions. Was there a camera in that hallway? The school says it wasn't working. The lawyer files a formal request to preserve the video anyway. They find other students who were there, who the school never bothered to interview, who say the other kid threw the first punch. Suddenly, the school's open and shut case starts to fall apart. Or consider the zero-tolerance overreach. Your daughter, an anxious kid, has a small pocket knife on her keychain that her grandfather gave her for camping trips. She's had it for years and forgot it was even there. Someone sees it, and now she's facing a mandatory 1-year expulsion for bringing a weapon to school. You're panicked, but your lawyer steps in and makes a legal argument. They argue that under state law, the definition of a weapon requires intent. Did she intend to use it as a weapon? Of course not. They argue that the punishment is grossly disproportionate to the offense and violates her due process rights. Instead of an expulsion that would derail her life, they negotiate it down to a warning, with the incident removed from her permanent record. But the most powerful role an education lawyer can play in discipline cases is to look beyond the behavior and ask one simple question. Why? Why is this happening? This is where we see the profound overlap between school discipline and special education. A huge percentage of kids with recurring discipline problems have an underlying and often undiagnosed disability. Let me paint a picture. A 7th grade boy, let's call him Leo, is constantly getting in trouble. He's disruptive in class, blurts out answers, can't sit still, and gets into arguments with his peers. He's been suspended 3 times this year for defiance and disrespect. The school has labeled him a problem child. His parents are at their wits' end. They've tried everything, but the calls just keep coming. They finally hire an education lawyer. The lawyer looks at the pile of discipline reports and sees a pattern. This isn't a bad kid. This is a kid who is struggling. The lawyer demands the school conduct a full evaluation for special education. The school pushes back. They say it's a behavior issue, not a disability. The lawyer holds their ground, citing the law. Reluctantly, the school agrees, and the evaluation reveals Leo has severe ADHD and anxiety. His behavior wasn't defiance. It was impulsivity. His disruptions weren't disrespect. They were a cry for help from a brain that couldn't regulate itself in a loud, overstimulating classroom. The entire narrative flips. Under a federal law called the Individuals with Disabilities Education Act, or IDEA, there's something called a manifestation determination review. If a child with a disability is facing serious discipline, the school has to determine if the behavior was caused by, or had a direct and substantial relationship to, the child's disability. In Leo's case, it's a slam dunk. The defiance, the disruptions, it's all a manifestation of his ADHD and anxiety. Because of this, the school cannot expel him. Instead of more punishment, the law now requires them to provide support. The suspensions are wiped from his record. He gets an IEP with a behavior intervention plan. He gets counseling, preferential seating, and scheduled breaks. The school that was trying to push him out is now legally obligated to help him succeed. Leo wasn't a bad kid. He was a kid with a disability that the school was punishing instead of supporting. The lawyer didn't just save him from another suspension. They saved his entire educational future. Accepting suspension after suspension isn't a neutral act. It creates a record, a paper trail that follows your child. It can impact their ability to get into certain programs, apply to colleges, or even join the military. Every suspension is a step away from the classroom and, for some, a step closer to the juvenile justice system. This is what experts call the school-to-prison pipeline, and it often begins with a seemingly minor disciplinary action that a parent felt powerless to fight. An education lawyer is the circuit breaker. They aren't there to excuse bad behavior. They are there to ensure fairness, to protect rights, and to force the system to look at the whole child, not just the incident report. They turn a moment of crisis into a chance to get your child the help they truly need. Because sometimes the loudest cry for help is disguised as the worst behavior. And the question is, who is listening? The school is listening. But what they hear and how they interpret it can be a world away from what your child is actually trying to say. This is where the battle for your child's future often begins. Not in a courtroom, but in a quiet, unassuming request. It's the request for an evaluation. And how you make that request what you ask for, and what you do with the results can change everything. Under federal law, specifically the Individuals with Disabilities Education Act, or IDEA, schools have an obligation called child find. It's a powerful affirmative duty. It means they can't just sit back and wait for children with disabilities to fail. They are legally required to actively identify, locate, and evaluate every child who might be eligible for special education services. It sounds great, right? A safety net woven into the very fabric of public education. But here's the reality on the ground. A school district might have thousands of students. Teachers are overwhelmed. Resources are stretched thin. And the line between a child who is just a late bloomer and a child with a genuine learning disability can look blurry from a distance. So what happens? Schools often wait. They recommend trying response to intervention or RTI, a process of providing more generalized support in the classroom. They might suggest waiting another 6 months to see how things go. They might tell you your child is just unmotivated, or that their behavior issues are separate from their learning. Waiting is the enemy of progress. Every day a child struggles without the right support. The gap between them and their peers widens. Their confidence erodes. Their anxiety grows. They learn to associate school with failure. As a parent, your gut is telling you something is wrong. You see the nightly homework battles. You see the light in their eyes dimming. You can't afford to wait. This is where an education lawyer shifts the entire dynamic. They don't wait. They don't hope. They act. They take your gut feeling and turn it into a legal instrument. They help you draft a formal written request for a comprehensive evaluation. This isn't a casual email to the teacher. This is a legal document that triggers specific timelines and obligations under the law. It states your concerns clearly. It requests evaluations in every suspected area of disability. It puts the school district on the clock. Suddenly, you're no longer just a worried parent. You are a parent formally exercising your child's legal rights. Let's talk about a boy we'll call Michael. In 2nd grade, Michael was a bright, funny kid who loved building complex Lego creations. But reading was like torture. The words seemed to jumble on the page. He would guess, get frustrated, and then act out to distract from the fact that he couldn't do what his friends could. His parents talked to his teacher. The teacher said, "He's a classic boy. He'll grow out of it. Let's just give him some extra reading time." They waited. 3rd grade came and the problem got worse. The school's solution was to put him in a lower reading group, which just made Michael feel stupid. His parents requested a meeting. The school psychologist did a quick screening and said his IQ was high and he didn't meet the criteria for a learning disability. He was just not applying himself. Frustrated and heartbroken, Michael's parents contacted an education lawyer. The first thing the lawyer did was look at the school's evaluation. It was little more than a single IQ test and a brief observation. The lawyer immediately told the parents about one of the most powerful rights they had, a right most parents have never even heard of, the right to an independent educational evaluation or an IE at public expense. Here's what that means. If you, the parent, disagree with the results of the school's evaluation, you have the right to ask the school district to pay for a second opinion from a qualified, independent expert of your choosing. The school has only 2 options. They can either agree to pay for the IE, or they must file for a due process hearing to prove that their own evaluation was appropriate. That's a high bar for them to clear, and it's often a fight they'd rather avoid. The lawyer helped Michael's parents draft a letter formally disagreeing with the school's assessment and requesting an IE. The school, faced with a legally sound request from an attorney, agreed to pay. The family found a highly respected neuropsychologist who specialized in learning disabilities. This wasn't a 1-hour screening. This was a 2-day deep dive evaluation. The neuropsychologist ran a full battery of tests, assessing everything from phonological processing and working memory to executive functioning and emotional regulation. The result? The report was a revelation. It was a 30-page document that finally gave a name to Michael's struggle: severe dyslexia, complicated by ADHD. The independent expert didn't just diagnose the problem. She laid out, in painstaking detail, exactly what Michael's brain needed to learn. She recommended a specific, evidence-based reading program, a multisensory approach to math, and accommodations like text-to-speech software and extra time on tests. Armed with this comprehensive, expert report, the lawyer went back to the school. The conversation was no longer about whether Michael had a problem. The proof was undeniable. The debate was now about the solution. The school could no longer say he was unmotivated. They were now legally obligated to provide a free appropriate public education, or FAPE. based on the specific needs identified in that independent evaluation. Michael got a robust IEP. He started receiving the specialized instruction he desperately needed. And slowly, painstakingly, the words on the page began to make sense. His behavior in class improved almost overnight because the source of his frustration was finally being addressed. He started to feel smart again. This is the power of a proper evaluation. It is the bedrock upon which all special education services are built. A weak, incomplete evaluation from the school leads to a weak, useless IEP. It's the classic garbage in, garbage out problem. The school's evaluation is designed to answer one question. Does this child meet the minimum criteria to qualify for services? They are looking for a reason to say no, or to provide the least restrictive, and often least expensive intervention. An independent educational evaluation, guided by your lawyer, answers a fundamentally different question. What does this specific, unique child need in order to make meaningful educational progress? It's not about just qualifying. It's about thriving. An education lawyer understands this landscape. They know which evaluators are the best in their field. They know how to craft the IE request so the school is more likely to approve it. They know how to ensure the evaluation covers all the bases. Not just academics, but also social-emotional health, speech and language, occupational therapy, and functional behavior. They are turning a moment of disagreement into an opportunity for true discovery. They are forcing the system to look beyond its own limited resources and standardized tests, and to see your child for who they really are and what they truly need. Without that expert evaluation, you're just guessing. You're trying different strategies, hoping something sticks. With it, you have a roadmap. You have a blueprint for your child's success, backed by data and expert opinion. It's the single most important document in your child's academic life. And getting it right is a battle you cannot afford to lose. And so you walk into the IEP meeting, holding that independent educational evaluation. It feels heavy in your hands not because of the paper, but because of the hope and the fight it represents. You believe this is your silver bullet. You believe that now, finally, the school will see the truth. They'll understand what your child needs. But then you sit down at the table. On your side, there's you. Maybe your spouse. On their side, there's the school psychologist, the special education teacher, the general education teacher, a district representative, maybe their own speech therapist or occupational therapist. A whole team of people who do this every single day. They have their own language, their own acronyms, their own agenda. And suddenly, that powerful report in your hands feels less like a silver bullet and more like a single stone you're supposed to use against a fortress. This is the moment of truth. The IEP meeting isn't just a collaborative discussion about your child's education. Let's be brutally honest about what it is. It's a negotiation. It's a legal proceeding masquerading as a parent-teacher conference. The document you create in that room, the IEP, is a legally binding contract between you and the school district. And in any contract negotiation, would you ever consider showing up without an expert on your side, especially when the other side has a team of them? This is where an education lawyer transforms from a maybe we should into a we absolutely must. Their work doesn't start when they walk into that room. Starts weeks, sometimes months before. A good lawyer prepares for an IEP meeting like a trial lawyer prepares for court. First, they strategize with you. They don't just ask, "What do you want?" They dig deeper. What does success actually look like for your child, not just this year but 5 years from now? What are the non-negotiables? What are you willing to compromise on? They help you see the long game, turning your emotional, heartfelt desires, "I just want him to be happy and have friends," into specific, actionable, and legally defensible goals. Next, they become a master of the record. They will comb through every single document. The school's flawed evaluation, your powerful new years of old IEPs, report cards, teacher emails, disciplinary notes. They are looking for the narrative, the pattern of denial, the places where the school failed to meet its legal obligations. They are building a case brick by brick before they ever set foot in the school. Then they seize control of the narrative. Most parents walk into an IEP meeting and simply react to the school's agenda. The lawyer flips the script. They will help you draft what's called a parent concerns letter and a proposed agenda, sent to the entire team well in advance of the meeting. This letter powerfully outlines your perspective, attaches your IE, and lists the specific topics you expect to discuss. It sets the tone. It tells the district, "We are prepared, we are organized, and we will not be sidelined." You are no longer just a participant. You are a co-leader of the meeting about your own child. Now, picture the meeting itself. The dynamic in the room fundamentally changes when a lawyer walks in with you. It's an unspoken signal. The tone shifts from casual and sometimes dismissive to formal and precise. The district team knows they can't use jargon to confuse you. They know they can't make promises they don't intend to keep. They know every word they say is being weighed against the law, the Individuals with Disabilities Education Act or IDEA, by someone who knows it inside and out. The lawyer levels the playing field. They are your shield. They are also your translator. The school team might say something like, "We'll be implementing a multi-tiered system of supports with a focus on differentiated instruction in the LRE." To a parent, that sounds impressive but means almost nothing. Your lawyer translates. They're proposing the standard lowest-level interventions in the general classroom, which the data has already shown is not working for your child. And they translate for you. You might say with tears in your eyes, "My daughter comes home every day and cries. She feels stupid. She's starting to hate school." It's powerful, it's emotional, but it's not a legal argument. Your lawyer reframes it. The current placement is failing to provide a free appropriate public education, or FAPE. The lack of appropriate services is resulting in a lack of meaningful educational progress and is causing significant emotional distress, which is impacting her ability to access the curriculum. Therefore, we are requesting a change in placement and the immediate implementation of the one-on-one, evidence-based reading program recommended in the IE. See the difference? One is a plea, the other is a demand, backed by law and evidence. Let me tell you about a family, the Jacksons. Their son Leo had severe dyslexia. For 2 years, the school had him in a small reading group using the same generic program that wasn't working. He was falling further and further behind. The parents begged for a more intensive, specialized program, an Orton-Gillingham-based approach. The school's response was always the same. "That's not a program we offer," which is code for, "It's too expensive and we haven't trained anyone to do it." So the Jacksons got an IE. The independent neuropsychologist came back with a 40-page report. The conclusion was unequivocal. Leo required, not just would benefit from, but required at least 1 hour a day of one-on-one Orton-Gillingham instruction with a certified tutor to make meaningful progress. The Jacksons hired an education lawyer. Before the next IEP meeting, the lawyer sent the school a letter with the IE attached, stating their position. The school's program was a denial of FAPE, and under the law, cost cannot be a determining factor if a specific methodology is what the child needs to receive an appropriate education. At the meeting, the district's special education director started with the same old line. "We understand the recommendation, but our teachers use a different, research-based program." The lawyer calmly interrupted. "Is it your position," she asked, "that your program, which has produced 2 years of documented regression for this child, is superior to the one recommended by a leading neuropsychologist? And are you prepared to defend that position in a due process hearing? Because my expert is." The room went silent. The director's face tightened. The lawyer continued, "The law doesn't say Leo gets the best education possible, but it does say he has a right to one that is reasonably calculated to enable him to make progress. This IE is now the most current and comprehensive data we have on this child. To ignore its primary recommendation is to willfully ignore the data. If you choose to deny this service, we need you to state that clearly for the record and provide us with a prior written notice explaining the exact basis for your denial. Every evaluation, record, or report you use to make that decision." It was a masterclass in negotiation. She wasn't yelling. She wasn't emotional. She was citing the law, leveraging the evidence, and creating a paper trail. She was making it clear that saying no would be far more difficult and legally risky for them than simply saying yes. 2 weeks later, the Jacksons' lawyer received a revised IEP. It included 1 hour of daily, one-on-one Orton-Gillingham tutoring, provided by an outside specialist, paid for by the district. The battle was over. Leo started to read. This is the power you wield with an expert by your side. And the lawyer's job isn't done when the meeting ends. The IEP is a contract, and like any contract, it can be breached. The school agrees to provide services, but do they actually follow through? Are the speech therapy sessions happening consistently? Is the aide actually trained and present in the classroom? Your lawyer helps you become an expert monitor. They teach you how to document everything, how to communicate with the school in writing, and how to build a record of compliance or non-compliance. And if the school fails to implement the IEP, the lawyer knows exactly what to do. A phone call or a formal letter from a law firm gets a much faster response than a parent's frustrated email. They can file a state complaint or even reopen the IEP meeting to enforce the agreement. They ensure the victory you won at the negotiation table becomes a reality in your child's daily life. Without a lawyer, you're a passionate advocate. With a lawyer, you are a formidable force. You're no longer just a parent fighting for your child. You are a parent fighting for your child's legal rights, armed with evidence, guided by expertise, and prepared for any obstacle the system throws your way. You're ensuring the blueprint for success isn't just a piece of paper, but a promise that is kept. But what happens when the school refuses to budge? What happens when, even with a lawyer and a mountain of evidence, they simply say no? That's when the battlefield shifts from the conference room to the courtroom. That's when you enter the world of due process. Due process is the legal arena where the rights of a child with a disability are ultimately forged and defended under the Individuals with Disabilities Education Act, or IDEA. It is not an IEP meeting. It is not a negotiation. It is a formal administrative hearing that functions very much like a trial. Think of it as a specialized court just for special education disputes. This is the final backstop, the mechanism designed by federal law to ensure that a school district, with all its resources and authority, cannot unilaterally deny a child the education they are legally entitled to. It is the ultimate leveler of the playing field, but only if you know how to play the game. So what does this process actually look like? It begins when a parent, or in some cases the school district, files something called a due process complaint. This isn't just a letter of frustration. It's a formal legal document that meticulously outlines the alleged violations of IDEA. It details every way the school has failed the child, from a flawed evaluation, to an inappropriate IEP, to a denial of services. This document is the opening salvo, the first move in a high-stakes legal chess match. Once filed, the gears of the legal system begin to turn. An impartial hearing officer is appointed. This person is like the judge and jury rolled into one. They are an independent, third-party attorney with expertise in special education law, and their job is to listen to both sides, weigh the evidence, and make a legally binding decision. The school district will be represented by its own attorneys, lawyers who often do nothing else but defend schools in these exact types of cases. They are experts. This is their home turf. Before the hearing itself, there's a period called discovery. This is where both sides exchange all the information they plan to use. Your lawyer will request your child's entire educational record, internal emails from school staff, testing protocols, everything. The school's lawyers will request your independent evaluations, communication logs, and records from private therapists. Both sides will also submit lists of witnesses they intend to call to testify under oath. This is not about surprises. It's about laying all the cards on the table. The hearing itself can last for days, sometimes even weeks. It takes place in a formal setting, often a conference room set up like a courtroom. Witnesses are sworn in. Your lawyer will present your case first, calling witnesses to the stand. This could be you, testifying about your child's struggles and your attempts to work with the school. It could be the independent neuropsychologist who evaluated your child, explaining their findings and why the school's plan is inadequate. It could be a private speech therapist or tutor who can speak to your child's progress outside of school, proving their potential. For each witness your lawyer calls, the school's attorney gets to do a cross-examination. They will probe for weaknesses, question their credentials, and try to poke holes in their testimony. And this is where a skilled education lawyer earns their keep. Their ability to prepare your witnesses for this grilling, to protect them from confusing or misleading questions, is paramount. Then the roles reverse. The school presents its case. They will call their own witnesses: the school psychologist, the special education director, the classroom teacher. They will testify that their evaluations were appropriate, that their IEP offered a free appropriate public education, that they did everything by the book. And now, it's your lawyer's turn to cross-examine. This is a critical moment. A brilliant lawyer can use the school's own documents, their own data or lack thereof, to dismantle their arguments piece by piece. They can catch a witness in a contradiction. They can expose how the school failed to consider crucial information or follow legal procedure. They can show the hearing officer that the school's case is built on a foundation of sand. Throughout the hearing, evidence is formally submitted: evaluation reports, IEP documents, work samples, email chains. Your lawyer will make legal arguments, citing specific statutes and case law, objecting to improper questions from the other side, and weaving all the testimony and evidence into a single, compelling narrative for the hearing officer. This is not a job for an amateur. Attempting to navigate a due process hearing without an experienced education lawyer is like trying to perform surgery on a loved one after watching a few YouTube videos. The risk of doing irreparable harm is just too high. At the end of it all, the hearing officer issues a written decision. This decision has the force of law. If you win, the hearing officer can order the school district to do almost anything necessary to remedy the situation. They can order the district to pay for a private school placement, a specialized school that can actually meet your child's unique needs. They can order the district to provide and fund thousands of dollars in independent services, like one-on-one tutoring or intensive therapy. They can order what's called compensatory education, or Comp Ed, which is a bank of services to make up for the skills and learning the child lost because of the school's past failures. This decision is the final word. Now, here's a crucial piece of inside baseball. The vast majority of due process complaints never actually make it to a full hearing. The simple act of filing for due process, of showing the school district you have retained a serious, knowledgeable lawyer and are prepared to go all the way, completely changes the dynamic. It's like pushing all your chips to the center of the table. Suddenly, the school's attorneys get involved, and they have a professional obligation to advise the district on its legal exposure. They know how expensive a multi-day hearing can be. They know the risk of a devastating loss, not just financially, but for their reputation. More often than not, filing for due process is the catalyst that forces a real, meaningful settlement negotiation. The school district, which previously refused to budge, may suddenly come to the table with a substantial offer. The very placement they denied, the services they refused, a significant Comp Ed package. Your lawyer's job then shifts from trial advocate to expert negotiator, ensuring that any settlement agreement is ironclad, comprehensive, and gives your child everything they need to succeed. The threat of the trial is often more powerful than the trial itself. And this brings us to the most important point of this entire series. The journey we've walked through, from the first gut feeling that something is wrong to requesting an evaluation, to navigating the labyrinth of the IEP meeting, to commissioning independent reports, and finally to the ultimate legal recourse of due process, is a testament to one fundamental truth. The system is designed to be overwhelming. It is complex by nature, filled with jargon, deadlines, and procedural traps. It favors the institution, the party with more resources, more experience, and more time. An education lawyer is the great equalizer. They are more than just a legal representative. They are a translator for the complex language of the law. They are a strategist who can see the entire chessboard, not just the next move. They are a shield, protecting you and your child from the immense pressure and intimidation a school district can exert. They are a sword, fighting for your child's legal rights with precision and expertise. Hiring an education lawyer is not an admission of failure. It is not an act of aggression. It is an act of profound advocacy. It is a declaration that your child's future is not negotiable. It is you, the parent, recognizing the magnitude of the fight and bringing in a professional to ensure you have the best possible chance to win it. Every family that successfully challenges a school district, whether in an IEP meeting or a due process hearing, does more than just help their own child. They create a ripple effect. They set a precedent. They send a clear message to that school, to that district, that parents are watching, that they know their rights, and that they will be held accountable. Your fight makes the path a little easier for the next family, and the family after that. It forces the system, inch by painful inch, to get better, to be more responsive, and to live up to the promise of providing a meaningful education for every child. So if you take one thing away from our time together, let it be this. You are and always will be your child's most important advocate. The law, specifically IDEA, has given you incredible power to shape your child's destiny. But power is only potential until it is used. An education lawyer is the key that unlocks that potential, the partner who helps you wield that power effectively. Your child's future is not a request to be considered. It is a right to be enforced. Never ever be afraid to seek out the champion you need to make that right a reality.